नमस्कार दोस्तों। इस वीडियो में हम डिस्कस करेंगे एक काफी इंपॉर्टेंट जजमेंट आई है फ्रॉम ऑनरेबल सुप्रीम कोर्ट इन द केस ऑफ आर्मर सिक्योरिटी वर्सेस कमिश्नर सीजीएसटी ईस्ट दिल्ली। और इस जजमेंट में ऑनरेबल सुप्रीम कोर्ट ने कुछ इंपॉर्टेंट जो कंट्रोवर्सीज थी उन कंट्रोवर्सीज को डिकोड किया है, उन कंट्रोवर्सीज को एक तरीके से क्लैरिफाई किया है। फ्रेंड्स, इस जजमेंट को ऑथर की है जस्टिस पार्डीवाला ने, and Justice Pardiwala has clearly and categorically laid down the conclusion and the guidelines for issuance of the parallel proceedings, or you can say for parallel proceedings under section 6(2)(b) of the GST Act, और उसका कंपैरिजन किया है with the inquiry initiated by the officers under section 70 of the CGST Act. Friends, as you all know that GST is a dual levy. GST is a classic example of cooperative federalism wherein both center and state levy a tax called GST together. They come together on a platform called GST Council and then they legislate the GST law. So suppose a taxpayer is assigned to the central GST department for its administration, and central GST department has issued a show cause notice on a particular issue. Now, can the state GST department, the counterpart of the central department, may issue show cause notice on the same subject matter on which the CGST is already doing the adjudication? So that particular, you can say that duplication of administration or duplication of same proceedings by two officers is basically prohibited under section 6(2)(b) of the CGST Act, or you can say the State GST Act. So now this judgment particularly was dealing with a peculiar, or you can say a strange controversy wherein State GST department had issued a show cause notice to a particular assessee, and the allegations were cancellation of some suppliers, and due to which ITC was disallowed. Post issuance of that show cause notice, the central GST department, you can say the counterpart department, anti-evasion, or you can say DGGI, conducted a search at the premises of the same dealer, and post search they issued summon to that particular assessee. So that assessee was aggrieved with the issuance of summon, and he replied that since I am already adjudicated by state GST department in relation to the cancellation of suppliers, the summons issued by you are barred by section 6(2)(b), so you cannot issue summons under section 70 because it is prohibited by section 6(2)(b) of the CGST Act. So this controversy ultimately landed in Honorable Supreme Court, and Justice Pardiwala compared, and you can say this is one of the beautiful judgment on parallel proceedings under GST so far, you can say. Justice Pardiwala categorically held that the 6(2)(b) of the CGST Act talks about initiation of the proceedings on the same subject matter. The important words are initiation of proceedings, the word proceedings, and the another important word is the same subject matter. And it was compared with section 70, that inquiry. In section 70, the officer makes an inquiry. The inquiry is not synonymous with the word proceedings, or you cannot equate the proceedings with the word inquiry. So the conclusion was that inquiry can be conducted by the officer, and if the inquiry results into the same subject matter, same allegations, then it won't be allowed. But if the inquiry results into some different allegations on some different subject matter, different period, then it can be allowed, and the show cause notice by the Central GST Department due to intelligence-based enforcement can be issued. So the conclusion of this judgment is that the word proceedings will include the issuance of the show cause notices and its adjudication by a respective department. So our humble advice is that whenever a case is conducted or adjudicated by a state GST department, or you can say the central GST department, and the another departments or the counterpart issues summons to you, you must attend the summons. The summons must not be left unattended because it may lead to severe consequences at your part. And this has been advised or suggested by Honorable Court in this case also. Post issuance of summon, if there are duplicate proceedings, then those proceedings won't be allowed in terms of Section 6(2)(b) of the GST Act. So friends, this was a very, very important judgment on Section 6(2)(b) of the CGST Act, that is the parallel proceedings. The case is Armour Securities versus Commissioner CGST East, and the SLP number is 6092 of 2025. And I hope you find this video to be useful.